Mr. Knox, I should let you know that we've now received the correct version of the Jury Act, and the version of Section 31 that was enforced then is much simpler, and I think it all makes sense.
Oh, I'm sorry it didn't make sense.
Well, it's rather easier to make sense of it.
But I'm grateful, my lord. I haven't.
All right, yes, so welcome again, viewers and subscribers. Morning, evening, night, whenever you check in as usual. Yeah, man, you tune to RyanmediaTv. And January viewers, the thing I get heat up in the courthouse, in the Privy Council there. So if the first are tuning in, yeah, man, please click the subscribe link, click the bell to be notified for any brand new video from this channel. And please to like the video. But as me say, viewers, yeah, man, we are giving you an update as we go along and how it twists go one side and then it twists come back this side, viewers and subscribers. Cause, me not tell a lie, all through the Privy Council trial, trust me, and one of the first time I see the prosecution team just laugh, so it's like them must say, yeah, them finally have the law, them where them want to have them and the lady. Yeah, man, viewers. So when me I go getting on, me I go showing them this because them get deep down in the evidence them where the juror them use and sentence Vybz Kartel, which you must show and say, yo, with them evidence here, them never did have to do anything else to the juror. And this is why the judge allow everything to just proceed. So, may I go just share this with you right now, viewers. Yeah,
my lord, I'm conscious of time. Can I just move on to my next point? The first point I'm making is you can trust the jurors. This was a question of prejudice, external prejudice. You can trust the jurors to obey their oath. That's my first point. The second point is this. For the purpose of deciding whether the jurors have complied with their oath, you look at the case as a whole, and especially two things. The overall strength of the case, because that goes to whether they would take any notice at all of the offers of the bribe, and secondly, the actual verdicts they came up with. If I can deal with the second point first, the verdicts. As I mentioned, Shane Williams was acquitted. The evidence against him was less strong. It was simply that he was identified by Chow as one of the men in a video talking about, or appearing to talk about, a killing. The case in which this point is made that you can take into account, or it's a point that matters, is the case of Sander, which is an ECHR case at 7965. I won't take you to it, but it's in the dissenting judgment of Sir Nicholas Bratzer. I think it was 4-3, but he makes the point that the Court of Appeal in England had found it a significant point that there were two Asians, one of whom was acquitted, one of whom was convicted. And that was a significant point in showing that the alleged racial bias didn't actually make much difference, or was unlikely to have made any difference to the jury's thinking. And likewise, I say, by parallel reasoning, here too, the bias, if you've expected the bias at least to be operative, or you would have expected Shane Williams to be convicted as well, but he wasn't. As to the strength of the case, if I can summarise it briefly, just take it to one or two passages. Prosecution evidence fell into 5 categories. First, there was Chow's evidence. That is summarised in the Court of Appeal's judgment at 5778 paragraph 9 to 5779 paragraph 12. In short, he goes along with the deceased, he's taken along with the deceased in the car with Campbell at the front, driven along, and then he says, because they're being summoned because the guns have gone missing, and then he witnesses the killing by the 4 appellants at the relevant premises, those premises being owned by Mr. Palmer. After that, he returns and he takes Mr. Palmer to hospital. After that, he is offered, they try to get him, Chow, to leave the country along with them, a few days after. That's the thrust of his evidence. Now, that was obviously evidence subject to a lot of challenge, but the real point about it is it was supported by all the technical evidence. It was supported by the technical evidence, the phone calls and so forth. Well, that was one category. The second category was the deceased's girlfriend's evidence, to the effect that the deceased was never seen after the 16th of August 2011, the inference being he was obviously killed on that day, as Choud said. The third category was the evidence of the police investigations after the killing, and in particular, the entire interior of the house where the killing took place was burnt on the 27th of August, about 2 weeks later. There was a foul odour there on the 29th of August, query what was going on, and then by the 30th of September, the entire rear of the house had been demolished. And that is, you get that at the Court of Appeals judgment 5780, paras 14 to 5781, 17. And the appellants were arrested on the 30th of September 2011, and that's 5781, 18. And the point about the burning of the houses is that this was Palmer's house, and there was no report of any damage being done to the house at all by Palmer, and that was a point that was made to the jury. How come, if he owns the house and it's been damaged or burnt down, or burnt at least, how come he makes no report of it at all? The next category of evidence was Exhibit 14C. That consisted of voice and text messages from Palmer, and they are summarised at E5803 to 5807, and they are also summarised in the SFI at E6135, para 10, to 6136, para 13. If I can just ask you briefly to look at the Court of Appeals summary of that evidence, because it just couldn't be clearer. E5803. A passage describing Exhibit 14C begins at paragraph 69, and then paragraph 70 describes or summarises the effect of the voice notes. In the original, they're quite difficult to follow because they're all in patois. But you can see if you read 70, paragraph 70 at 5803, on to, if I may ask you just to read yourselves to 5806, the end of 5806, you can see the nature of this evidence. And in particular, you will have seen in passing 5805, paragraph 73. This is Palmer's text a few days after the event. Between me and you, the recipient's not identified. We chop up de boy lizard, that's the deceased's nickname. Fine, and dashing we enough. As long as you live, dem can never find him. Oh, couldn't be clearer. But the whole picture couldn't be clearer. And then we have also from JS2, I'm just going to give you the references. We have the texts between the deceased and his girlfriend, in particular on the 16th of August 2011. They are summarised at E4788 to 4791. And you can also see a shorter summary at in our written case at 6227.
Can you just give those references again?
Of course. Yep. 4788.
Yes, thank you.
4791. And in our case, they're summarised again at 6227, paras 40 to 41. But those texts show without a shadow of doubt that the deceased was on his way to be executed, and he suddenly realised what was going to happen to him. There can't be any doubt about that. There are some texts also from Palmer. They were of no significance, but there were texts from Sean Campbell which, to an extent, were incriminating, which suggested that on the day of the killing, but before the killing, Campbell said, who thief it, go dead. That's say, whoever stole it is a dead man. And then after the event. But the references, you can see those texts at 4989, lines 1 to 14, and 4990, 13 to 4991. So they're plainly incriminating. Now, the defence cases, and it's important to understand what the defence cases were, they all just gave unsworn statements. Palmer's case was simply that he had never met Lizard at the premises on the day in question. And, my lords, that is at 4341. I should emphasise this. The SFI says that Palmer says he wasn't at the premises. That wasn't actually what he said. He said, I didn't meet Palmer. I never met Lizard at the premises. Rather different. So he doesn't give an alibi. The important point is he doesn't say, oh, I was at a concert or whatever, somewhere in Kingston. No alibi. Campbell, in his unsworn statement, accepted that he drove, he says, ahead of the deceased and Chow in another car to the premises, but he says the deceased got out before getting to those premises. And when Campbell got there, when Campbell got to the premises in question, he says he left Chow there. In other words, Chow did go there, but Campbell says he then left. And later, he saw that Chow, later that evening, he said the only thing Chow mentioned was that Palmer had received a dog bite and had to be taken to hospital. That's 4383 to 4386. Jones's defence was a very short statement. He just said the police were lying about him. That's 6137 at 16, or that's the, I think, of the SFI, and in the record, 4387 to 8. And St. John said he left the premises just as Chow entered, and he saw Palmer getting bitten by a dog. And that's 4390 to 4392. The short point is that there was no denial, as far as one could take out, that they were there. And that is significant because the premises are then subsequently destroyed a few days later, or partly destroyed. And there's no explanation for this. Now, as to the exhibits, X14C, Exhibit 14C and JS2, their cases were simply this. The police have fabricated them. There's just a giant conspiracy to fabricate a whole mass of evidence. And there were challenges to the chain of integrity that went to that. That was it. But there was no explanation as to why the police should have done any of this at all. Now, my lords, bearing all that in mind, we say this was an overwhelming case where, for some reason, the only real question was, were the police in some way motivated, or did they fabricate all this evidence? That was the question for the jury. And, my lords, my lady, I respectfully submit there was nothing to support that. It's difficult to see, therefore, in those circumstances, why the alleged, or rather what you might call the bribery, would have made any difference to the consideration of their verdict. And I do submit the strength of a prosecution case in circumstances like this is a material factor. When one was asking, the question is there a risk, a real risk, that the verdict was influenced by prejudice? And I say, no, there's no real risk of that. My lords, my ladies, as far as the jury retirement point is concerned, that's what we say. So we say there was a fair trial. And the fundamental point is you can be satisfied that that 10-1 verdict was a verdict given by the jurors, or the 10, in accordance with their oath, uninfluenced by bias, prejudice. And if that's right, I submit the appeal must be dismissed. The next question I can deal with very briefly is the jury retirement point. My lords, my lady, I submit the following very short points. At the time, that's in 2011, there was no established practice written in a bench book or anything like that. The matter was left to the judge's judgment as to when to send the jury out. Second, I am informed by the Director of Public Prosecutions, who was here, who will provide more detail on the point. In real life, juries never take more than about a couple of hours or so to come up with their verdicts, even after long trials. And it is unheard of for them ever to have to be sequestered in a hotel room overnight. It just doesn't happen. Thirdly, there was, in my submission, no pressure applied by the judge in his directions. This is not a case where there was something the judge said at some point which suggested to the jury, you better get on with it. Far from it. There is at no point anything which the judge says to the effect, I do want you to come back in an hour or so, or please make your minds up, and so forth. So, nothing at all. No criticism of what the judge actually says. And finally, and I submit importantly, the Court of Appeal, who know all about this, how the system works, saw nothing wrong in what had happened. And if I can give you the reference, it's E5854, paragraphs 203 to 205, where they describe, where they go through some of the cases about sending juries out in different jurisdictions, and then again at 209, where they come up with... 5854. Paragraphs 203 to 205, where they discuss the background and various other cases, and 209. And they discuss one or two Privy Council cases where juries have been sent out actually rather later, but although the Privy Council has disapproved of that, nonetheless the convictions were upheld. But in my submission, the Court of Appeal was perfectly entitled to come up with the conclusion they did. No error of law has been identified in anything the Court of Appeal said, and I submit that it's not right, it's not the board's place to interfere with the Court of Appeal's judgment on these matters. Very briefly, the proviso, in one sense, my point on the proviso is this. Even if, let us say, the judge's directions after the jury incident were not as strong as they could have been, or should have been, or even if the retirement was too late in the day, there is still no reason to suspect that the jury was infected by bias or the risk of bias, given all the matters I have said. That being so, even if there was some irregularity or some imperfection in the way the trial was conducted, this is a case where there has been no, to use the words of the statute, no substantial miscarriage of justice. I should emphasise that I accept that if there was a risk of bias, a real risk of bias in the verdict, that would mean the trial was unfair, and that would also mean that you couldn't apply the proviso. An unfair trial is written water. But if the trial was fair, in my submission, you apply the proviso.
Do we have the statutory provision that contains the proviso?
I think we do. Yeah. In the bundle. For some reason, I seem to remember reading it recently. If I'm wrong, I'll be corrected. Perhaps I can...
Perhaps you could have the reference later.
I'll give you the references if I can find it.
Thank you very much.
My lords, my lady, that is only one point.
Yes, I think it's page 6806.
Thank you.
I think it's in the standard form of wording you're probably familiar with from other jurisdictions.
Well, I have noticed that they vary on
Well, the one we've been given
that's why I asked.
is the Judicature Appellate Jurisdiction Act, and it's section 14, the proviso to section 14.1.
Thank you.
All right, then, welcome to the end of the show again. And there you have it. Yeah, man. As me tell you, it look away right now. You see me? When the man go in at the evidence, you notice the lords and the lady, them even question it is like, trust me. Me don't know if they're not overs who are going yet or them are going at it. But trust me, this can be a turning point. Remember to tune to Ryan Media TV. Follow me on the IG. Big up.